Hey, all you sports fans, or to you, the individual, as part of the collective out there in the tubosphere, welcome to the One-Man Sports Rant, talk radio version. I am your host, as it were, Will, the alternative ESPN Sports Throw. All right, so we're talking, the Aaron Hernandez deep doo-doo trial. Well, of course, the trial hasn't even started yet, but it's not looking good. We're bringing you some of the relevant moments from the bail hearing earlier today. And you got to feel for the guy. I'll get into that in a minute on the sport rant of the day. We don't usually do this on the talk radio version. The beauty of the talk radio version is it's always going to be 3 minutes or less. We always have to do a show. It's called the DMCA. To do a show in one form or another because of the Digital Millennium Copyright Act. Covers the fair use standard, minimal use, derivatives. When you're borrowing others' content, there has to be an amalgamation of aforementioned minimal use with your own original content. So I'm going to stretch the limit here because ESPN was covering it, but so are many other news networks. So I guess the video highlights go to mainly courtesy to the state of Massachusetts, federal district court system, and to ESPN, all the other original graphics, which is not much to say, and the overall concept, copyright to the OMSR. I wasn't going to do a show on set and break out some Colorado colors. Why? Well, you'll hear that in a minute, but I didn't want to make a spectacle of it. It's really sad what's happened to him. I always have to question, these guys get affluent, who they're rolling with when they're not being this fine, upstanding football players you may see. Just like actors you may see whom you love on screen, and they're not the greatest of people in this town. We being of the OMSR of the team, Western San Fan Valley. Know quite a few of them, like a lot, can't stand a few of them. The point is, this kind of a case has not happened in quite a while of such notoriety on this degree. Not counting Michael Vick, okay, that doesn't count. We're talking, this is like end of your life stuff. Since Ray Caruth, Colorado. Who? You may say Ray with an A-E. Caruth. Your last bona fide 4.240 in college football. Colorado start 2 years, I think it was 96 and 97, 95 through 96. 2 years in the NFL, he helped to get, whom was it? Was it Jacksonville? Or I know it was back east. It might have been Tennessee, but I'm thinking Jacksonville. I could have looked this up, but this is why you watch the OMSR. I go from memory. I don't always look at my factoids. Try to get you guys involved too. You can always correct me. Jacksonville or Baltimore. Anyway, he got hung up with the, accessory to second-degree murder of his girlfriend type deal. Yeah, so that was that. This sort of thing hasn't happened since then. Look it up. You'll see I'm right. And the rest of the graphics the highlights, it's not so much a highlight, but it is a court proceeding, and that judge wasn't buying it. Thanks for watching those silly DUIs while you're out there. Don't end up in front of a judge like that type deal. That's about the silliest thing I can say in an otherwise serious situation. Roll graphics.
I have received the written filings from Mr. Sultan and Mr. Fee. I've also received some documents in connection with the bail review papers. Do you have notice of the comments requesting county's papers?
I'm sorry, Your Honor?
Do you have notice of the comments requesting county's papers?
No, Your Honor.
Do you have copies of the papers?
Copies of the papers that came from the district court?
She already looks annoyed.
Yeah, copies of the papers that were submitted by the district court.
Not a good way to start off a defense.
First question?
Well, I have a motion to impound in front of me because they were already impounded in the district court, and they're requesting that they be impounded in the Superior Court as well.
I have no objection, Your Honor.
All right? The good card is shown, the motion to impound will be allowed, but no objection being lodged. Do you have copies of the defendant's filings, Mr. McCall?
Don't, Your Honor.
Left it on your desk.
Oh, I'm sorry. Thank you. Thank you, yes, Your Honor.
Okay. So, Mr. Sultan, I'll hear you.
Thank you, Your Honor. As the court knows, bail in a murder case is discretionary. That does not mean it's not available. It is available, and there are numerous cases in which bail has been granted to defendants facing murder charges. I've cited several of them in my papers. If I could submit to the court, we've tried to gather a number of articles in a hurried fashion. If I could just submit them, which shows a number of other cases. These are really newspaper articles, they're not court cases, but just I can submit them to the court if the court wants to see them, showing that there are a number of other cases where this has been done.
Have you given copies of those to Mr.
I have them right here, Your Honor.
Okay. Mr. Sultan, I think we're all in agreement that it's discretionary within the court.
I'll submit them for whatever they're worth, Your Honor, but I think we're in agreement.
And I think we're also in agreement that it's very rare.
Well, Your Honor, it is true that more often than not, defendants are held in first-degree murder cases. However, as the SJC has said repeatedly, the purpose of holding somebody without bail is essentially, or to admit them to a high bail, is to ensure their appearance at trial. And I think that is, while there are a number of factors the court needs to look at, that is really the lodestar that the court has to keep in mind, which is, if I'm going to hold somebody without bail, am I doing it to ensure his appearance before the court? That's really what bail is for. That's what the SJC has said repeatedly. Now, the factor you start with first, and I understand, Your Honor, that the statutory factors enumerated in Section 58 don't strictly apply in first-degree murder cases, but I think the SJC has made clear in cases like Querubin and Hodge and other cases where they've talked about bail in other contexts, that the factors are really the same. They're the same factors judges have applied for hundreds of years in bail contexts. And you start with, of course, the nature and circumstances of the offense. And if the fact that it's a murder case was enough to deny bail, if that was it, then there wouldn't be bail available in first-degree murder cases. But that's not enough. Of course, Mr. Hernandez is charged with a very serious crime, but that shouldn't be enough to hold him without bail. And frankly, based on what the district court articulated, that's essentially why he was held by the district court. There were no findings made on any other factor. The reason he was held is simply, according to the written decision of the district court judge, because of the nature of the charges, period. That, I submit, is not a sufficient reason to hold somebody without bail. And I ask
you think he's going to win her favor?
As far as
let's fast forward and see.
The Commonwealth yesterday articulated in court a detailed timeline, which is essentially their theory of the case. But this is a case where, at least as far as we know, there is no eyewitness testimony, there are no inculpatory admissions, there has been no indication of any direct evidence as to who shot the decedent, who was present when the decedent was shot, whether there was a plan to kill the decedent, and any evidence indicating that if there was such a plan, that Mr. Hernandez was part of it. They may have such evidence, they may not, Your Honor, but they haven't shown it to us as yet, where he lives. These are where his roots are. So, again, in terms of factors the court looks at bail, articulated over and over again in these cases, in terms of his ties to the community, his personal living situation, that is something which I submit the court needs to take into account. So, now we turn to risk of flight. And as a practical matter, Your Honor, Mr. Hernandez does not pose any cognizable risk of flight. Number one, he is a well-known individual. And even if he wanted to run somewhere or hide somewhere, which he doesn't, as a practical matter, he couldn't do so. And his conduct, Your Honor, in the 8 or 9 days between when this very public investigation began and when he was arrested, I think says a lot about the fact that he is somebody who should be admitted to bail. He knew that all this attention was on him. He was the one being investigated. There were all these reports, unfounded and otherwise, that there was an arrest warrant for him. His arrest was imminent. He didn't go anywhere. He didn't move. He stayed in his home. The only time he left his home was to travel to Boston to meet with his lawyers, and when he did so, we called the Bristol County District Attorney's Office and said, by the way, we want you to know our client is coming to Boston to meet with us. We don't want you to think he's doing anything improper. So they knew where he was. He didn't do anything to hide. He didn't do anything to run. He cooperated fully when the police came to his house on multiple occasions to conduct search warrants, execute search warrants. And indeed, we informed the District Attorney's Office, if you really do have a warrant for Mr. Hernandez, he's happy to surrender himself. We'll surrender him at a time and a place that you say. They chose not to do that. They wanted to arrest him at his house. to arrest him in front of his fiancée and his baby, and to drag him out in handcuffs in front of the media. That was their choice. It wasn't necessary because he was a flight risk. He was not a flight risk then, and he's not a flight risk now.
In the case of Leon Abrams versus the Commonwealth, which actually had indicated that the Bail Reform Act, Mass General Laws 276, Section 58, do not extend to a person charged with murder in the first degree. And secondly, as that applies to, there was a single justice opinion, and I have the citation.
Do you have a copy of those?
I'm waiting on a copy, Your Honor. I apologize. I just come across this, and they're running that for me. But the single justice opinion, 2002-0483, it was the opinion by Justice Judith Cowan of the Supreme Judicial Court in exactly the circumstance we find ourselves today, which is district court judge set bail in a murder case, that didn't set bail, held the defendant without bail. It was appealed to the Superior Court. Superior Court then permitted some reduction of the setting of bail. That was then appealed by the Commonwealth, I believe it was Suffolk County DA's office, and that decision was vacated by the single justice. So I would make that as my first argument, that the defendant's petition should not be allowed based on the legal principles articulated by Justice Cowan in that matter. Secondly, on the issue of whether the defendant should be held without bail pending his trial, I would rely on the affidavit that the court has. I could give a full recitation. I'm prepared to do that. I think most of what I would say has already been captured or encapsulated in that affidavit. But in addition to what is encapsulated there, the case, the evidence presented, I disagree with my brother's representation about the strength of the case. I would suggest the evidence has established an overwhelming amount of evidence demonstrating the defendant's guilt. Since the time I appeared yesterday in the district court before Judge O'Shea, there was a search warrant while we were in court yesterday that was executed at a condominium that's being leased by the defendant. In that condominium, there was found, and as the brief or the affidavit articulates, the defendant, in his home, there was a prior search warrant for 22 caliber ammunition. There was a 22 caliber firearm that was found a distance between the murder scene and the defendant's house. In that condominium, there was 22 caliber ammunition, similar to the ammunition recovered in his house, and also which would work for that particular gun.
Well, that don't
sound good. The murder weapon in this case is a 45 caliber firearm.
Depends on the imprint the hammer put on it, of course.
5 shell casings found at the scene, 3 of which led to the body, indicating there was a number of injuries. As the victim was shot, he attempted to defend himself by putting up his arm. The first round struck him in the outside of his forearm, traveled through the inside of the forearm, and entered his body, the right abdomen. From there, he began to turn and was shot in the back 2 times. And then, after he was on the ground, the ballistic evidence would show that the defendant and Confederates advanced on him while he was down, shot him twice through the chest, in the area of both of his nipples, and those projectiles were recovered right under his body. They were 45 caliber projectiles. All of the rounds were matched to the same unknown firearm. There was a shell casing found under the driver's seat of the car that the defendant was driving from Boston. His movements were tracked from Boston all the way to where the vehicle is seen going through the industrial park into an area that was consistent with his drive
right there.
Home. It went in there at approximately 2:26 in the evening. It exited 3 minutes later. There were gunshots that were heard by people who were in the area during that time.
I don't know any of the other cases, the facts of any of the cases that we talk about, but this is not a first-degree murder charge where the facts support perhaps sudden combat or heat of passion or anything else along those lines. The facts, as I understand them, and I think the Commonwealth has presented a case that circumstantial, to be sure, but very, very strong circumstantial case. The facts, as I understand them, as they've been presented to me, if believed by a jury, that this gentleman, either by himself or with 2 other people that he requested come to the Commonwealth, basically cold-blooded, in a cold-blooded fashion, killed a person because that person disrespected him. And if that's true, and it's based upon the presentation seems to be, I'm not confident that that type of individual would obviously doesn't comply with societal rules, and the idea that I could release him on a bracelet and he would comply with court rules is not something that I'm willing to accept. I've given all of the circumstances in this case. Despite the fact that he has a fiancé and a baby and is a homeowner, he also has the means to flee, and a bracelet just wouldn't keep him there, nor would $250,000. I'm going to deny the defendant's petition.
Aaron Hernandez, petition 2013-770 is denied.
Your Honor, sorry, has my filing been, is it impounded or not? Does the court impound my filing? I don't.
Did you request that?
No, Your Honor.
Okay. Then it doesn't seem to me that there is any reason for it to be impounded. Thank you.
Thank you, Your Honor.
So be
And there you have it. 35 minutes after this petition for bail for Aaron Hernandez began, it ends. Much longer than many people expected it to go, but 35 minutes and Aaron Hernandez has been denied bail. So therefore, he will be going back to the Bristol County Jail where he spent the night last night, overnight. I believe the woman you're seeing there with the dark hair is the girlfriend of Aaron Hernandez, who we saw coming out of his home yesterday, a few hours after he was arrested. Try to confirm that, but that is the same woman that was seen coming out of his home a few hours after he was arrested yesterday on murder charges. You can see it's an emotional scene inside the courtroom for her, probably for many others on both sides of this case, as people now realizing how serious this truly is, and that Aaron Hernandez is obviously in some trouble. The specifics of this case, once again, first-degree murder charge in the death of 27-year-old Odin Lloyd, along with the gun-related charges, 5 of them. Again, Aaron Hernandez will be transported back to Bristol County House of Correction and Jail in North Dartmouth, Massachusetts, as we take another look close up at, again, the woman who we believe is the girlfriend of Aaron Hernandez, now former Patriot tight end.
Nothing really unexpected here. We heard what the defense said, and of course they could focus on really the only thing they had to focus on, which is, you know, Judge, he lives in the area, he owns a home, he is a father, he has a fiance, he has a stable life. But the allegations in this crime are just so overwhelming, and that it's hard to imagine that some judge would let him out of jail, even on any combination of bail and restrictions and call-ins and,
don't know who Roger. He used to be with Greta Van Susteren on
is what we see, that he's just
CNN. They did a show at 9 in the morning.
Jailed, certainly before his trial.
Roger, your thoughts on,
Like
on the
12 years
argument
ago.
presented by Hernandez's attorney, specifically James Sultan. Many points, very, very interesting, but one thing that stood out to me is when he was describing Aaron Hernandez's personal characteristics, the first thing he went to was his football accolade. Interesting to you?
Well, look, he is an accomplished football player, and that's what he does for a living, and he's very, very good at it. And I guess what the attorney was trying to say is, Judge, he's great at what he does. That takes a great deal of responsibility. It takes a great deal of practice. You can rely on him. He has shown the same kind of professional traits that others show. It's just a tough argument when you're making those arguments. I've had to make those arguments, and I've had to counter those arguments, and there's just not much to say, because at the end of the day, it gets back to that horrible thing about what the crime is, and that's really tough. I mean, how do you get around that? And you heard what the judge said. The judge said, look, this is a crime here where the allegations are basically an execution murder, and people just don't get out of jail with those kinds of charges.